Hello, it's Jenkins, the family law vlogger here. This is a vlog in the Stages of Divorce series, and today I'm looking at what a chronology and a statement of issues are in financial remedy proceedings. So what are these documents and when are they used? So they're generally used in financial remedy proceedings, which are the court proceedings that are used if people haven't been able to sort out their finances following their divorce by other means, such as mediation or negotiation between themselves or solicitor-led negotiation. So when do these documents crop up? Well, they crop up partway through the proceedings, once people have done their financial disclosure, provided all their financial information in Form E with all the supporting documents. And they are usually prepared by clients or their solicitors in the run-up to the first court appointment, called the first directions hearing, or the first appointment is the technical name for it. Now, sometimes these documents are still used, and to be honest, sometimes they're not. Under previous court rules, a chronology and a statement of issues had to be provided for the judge for the first court hearing at financial remedy proceedings. Now, to some extent, that's still the case, but they've slightly been superseded by some newer forms called an ES1 and an ES2. The ES1 being a case summary, and the ES2 being a composite financial summary of the schedule of assets and income. And there are separate vlogs on what an ES1 and an ES2 is. But the rules still provide for, but local courts often give their directions as to whether they still want to see a statement of issues and a chronology. So what are they if you do have to provide them? So a statement of issues is the one that really has, to some extent, been superseded by the ES1 case summary, because the statement of issues is what it says on the tin. It's a list of the issues in the case between the parties, so by reference to the Form E. So, for example, you would expect to put in there whether there is a difference about the valuation of property, or whether there's a difference between you about the valuation of businesses or trust interests or of any other assets. You'd expect to put in a statement of issues whether there was any issue about the origin of assets, so whether assets were premarital or acquired post-separation. You'd expect to put in there if there was a dispute about what the extent of the assets were, so if one person is saying that the assets are bigger because one party hasn't disclosed what all of the assets are. So it's a statement of issues in the case to give the judge at the first hearing an indication of what the issues are, and therefore what directions the judge needs to give at that hearing, whether it's valuations or further evidence or further information from one of the parties. Now, as I say, to some extent that's been superseded by the case summary in the ES1, because there is a section about those sorts of issues in the ES1. So that's where it's slightly odd that we still have a schedule of issues kicking around, and some courts do still want it. Likewise, in relation to a chronology. So the chronology, again, is what it says in the name of it. It's a list of dates, so the key dates in the case. So usually when the parties were born, when they met, when they started cohabiting, when they got married, when any children of the family were born, when any key assets were acquired. So, for example, an interest in a family business, or the sale of a major asset such as a property, or some other significant event, for example, say the death of a parent who then provided some resources that became inheritances for one of the parties. Same towards the end of the marriage, when the parties separated, when they started living apart, when the divorce proceedings were started, etc. So again, it's to give the judge at the first hearing the key information to go and get a quick overview of the case without trawling back through the Form Z and detailed paperwork before him or her, or then at that first hearing. Again, the chronology has to some extent been superseded by the ES1 form, which is now required before a first appointment, because that has dates for things like dates of marriage, dates of separation, dates of birth of any children of the family. But sometimes you'll still see courts wanting, or solicitors suggesting, that you should have a schedule of issues, or a chronology, or both. So I wanted to explain how they fit into the process. As I say, they're usually done, if they're done at all, before a first court hearing, to give the judge at that hearing an idea of what the issues are, and therefore what directions he or she should give at that hearing. But if you have any questions about your circumstances, any specific advice you need on your situation, or circumstances that relate to you or to your family, then please do contact me or one of my colleagues in our expert Mills Reeve Family and Children team, and the details are below this blog. Thank you.